It also come. The conversation over the past weeks has been issues surrounding attempts to Chief Justice Gertrude Torkonoo. Well, she's been suspended, but a number of Ghanaians seem to be interested in the issue. They raised issues about unconstitutionality. Old Tafo Member of Parliament, he's been to the Supreme Court. He's tried injuncting the process, but that was unsuccessful. And new to this is that her ladyship, she filed a case at the Supreme Court. She's been represented former Attorney General Godfred Yeboah Dame. We are just of the former Attorney General on this and other issues emerging out of the attempt to remove the Chief Justice. To Channel TV. It's been 4 months after the NPP lost the election. A lot of the NPP folk we know said it was a difficult defeat, a moment for them. How was it for you?
Well, I think this is not the first time I've been in opposition. We were in power from 2001 to 2009, and we were in opposition. And some of us, we had our law practice. Our law practice tried, and so for me, the only change is, of course, the office at home. But in terms of law practice, it's business as usual. Because the office of Attorney General, for me, was a professional office in a way. Even though the Attorney General wears two hats, Minister of Justice, by virtue of which he sits in cabinet. The private functions of the Attorney General essentially are law related to the Minister of Law and ensure that there's sufficient and social justice in the country. So I enjoyed it, and I still enjoy law practice, just as I did before I went into government.
So the switch wasn't difficult. I mean, books coming back, going to court, and being on the defense side rather than being on prosecution.
Oh, definitely not. I mean, as I've said before, we only was on a permanent office. There, we are Attorney General. Yes, we cannot be Attorney General for life. So, yes, the only difference is the kind of service that was rendered. That was public service. But now it is private law practice, and so I can charge you fees to enforce it to me. But of course, I will not.
No, it should be new, right? A lot of people knew you from your days at Ekufado Prempen Court. Is that Dame Partners new, or it's been there while you were still at Ekufado Prempen?
So, interestingly, Dame Partners has been competent since 2017.
Wow.
I was at Ekufado Prempen Court, started from 3rd October 2020, 2003. And then by 2017, after 14 years of practice with the Godfred Dame, I felt that it was time to go and establish my own law firm. So indeed, in January 2017, I incorporated Dame Partners with a view to moving into private practice from a different chamber. That's my own chamber.
Oh, so this is not a post-2024
Definitely not. The documents of incorporation are there. I followed it in 2017, but consistent with my virtues, I decided to do it on ice, essentially. I did not have a law firm activated because right after I incorporated, the president nominated me as deputy attorney general. So I said, well, I did not want a situation where conflict of interest, whereby my law firm will engage in cases. People will say that I'm assigning cases from the office of attorney general to my law firm and that kind of thing. So I decided to just keep it on ice. There was no practice at all. So right after we lost power, not after we lost power, right after we officially exited office, I revived the office. So we didn't know time about a month or so. I took a month's rest. Thereafter, I obtained my solicitor's license, chamber registration license, and then the law firm started.
How has it been so far? I mean, running your own private practice?
Well, it's been interesting, it's been good. We have the freedom of choice in terms of selection of clients. You know, of course, I do a lot of pro bono work as well, as I used to do. You know, and so of course we also have to keep body and soul together. So there's a lot of commercial practice as well.
Anybody who knows you would be fair to say that the modus operandi really hasn't changed that much. Because then PP in opposition, you will take a lot of constitutional cases. The Ejechum and the rest, you were involved in those cases. But is it fair to say that this is the biggest case?
As you yourself indicated, I've been familiar with these kinds of cases. I remember the very first prosecution of officials in 2009, and then from our foreign minister, the Justice Gertrude Torkonoo. That trial was conducted by me successfully. So, because of financial laws, breach of procurement law, and abuse of office of profit, and I succeeded in that. The trial did quite, including the president himself, I was his lawyer in various matters, actually challenging whether he was a lawyer or not. So I'm used to that. In terms of that, yes, we have been having the matter of public sector workers. We took on this challenge. Constitutional cases are really not new to me, and I believe that is why the lady Chief Justice, the recognition of my humble expertise in that regard, decided to call on me and to assist. Well, it's something that I've always been speaking about, independence and judiciary and all that. So I have no difficulty at all lending my assistance.
We'll come back to what people have been saying about your involvement and whether it is good for the case or not. But did this case find you, or you found it? I mean, we know that the Old Tafo Member of Parliament, he went to the Supreme Court, even before the CJ engaging you. Did you have or taken up a matter, or he approached you?
No, so he approached me. I mean, Vincent Ekow Asafuah, that he was really concerned about the happenings in the country, the attempt or vet, as it was, to remove the Chief Justice from office, and that the constitution. And I knew that the provisions of the constitution examining the relevant best practices, and I recognize that clearly what is happening in the country betrayed a litany of constitutional violations and all, and therefore it was appropriate that we took up the challenge, which we did. It is still pending before the court. It's not over. It is only the injunction which are in the space. So we filed a signal of case already. Next week we'll be setting out the issues for intervention by the court, and then we'll have the court head the matter of this merit.
Is it you have taken an entitled and an entering position to say that everything about the processes to remove the is constitutional? Because from the beginning, when the president says he's consulting the council of state, that they're raising issues about unconstitutional with the unconstitutionality with the process till date to the formation of the committee, and even objecting to some members of the committee. It looks like every step of the way you want to find a problem.
I mean, it cannot be an entrenched position at all. The point is that we have a constitution, and we have the spirit of the constitution, which essentially sets out the rationale behind the various provisions that we have there, and how they ought to work out in a way as to achieve the proper functioning of the society. And it's also interesting to note that when I was in office as Attorney General, I actually started the process of enacting regulations to govern the operation of anti-war forces. It's something that is in the office of Attorney General. The Director of the Executive Drafting will have it. The current Attorney General, I'm sure, Vincent Joseph will have it, and will know. So,
what's started?
Yeah, because the process of enactment of legislation, whether subsidiary or primary, goes through a process. It has to go through stakeholder consultation, in the first place, we actually received a letter from the Judiciary Council. Yeah, the then Chief Justice wrote asking us to commence the process of enacting regulations to govern Article 146. We started, we did a full draft. I have a copy that I can even share with you. Subsequently, we set it for stakeholder consultations, which is eliciting the views of various stakeholders, the Judicial Council, the Calabar Association, General Legal Council, and all. As to it is after that the legislation could be laid in Parliament. And we could not complete that, and then this came away. So, where is that to continue?
Let's talk about the current case as we have it. The issue with which you are representing the suspended Chief Justice. A lot of people seem to find the views you're pushing in that very interesting. The first one has to do with the demand for the hearings to be public. People say that it's an open and closed book. 1468 says all proceedings should be in camera.
So, I think it's important to indicate that number one, this is the very first time a Chief Justice has had to issue a writ in the court of Ghana. It's never that has never happened. And that's because the Supreme Court has always been the bulk of the protection of the independence of the judiciary. Clearly, any time that there's an attempt to remove a Chief Justice in this country, the Supreme Court has to intervene. And that intervention is on account of the fact that there ought not to be any interference whatsoever by any person in or in the independence of the judiciary. And so what is happening is quite interesting. I would say that whenever there has been an attempt to undermine our democracy, it has always begun with the judiciary. Like I cite the example of the first republic. In 1963, there was a removal of 3 Supreme Court judges, in fact, the dismissal of 3 Supreme Court judges, including the Chief Justice, Sarah Kokosa. Within a few years down the line, there was chaos, and then there was a coup d'etat. Because it was thought that if the primary institution, which would be the board for protection of rights in the country, therefore ensuring that whenever the executive wants to overreach its powers, it's brought in check, has been interfered with, then there's no hope at all for the society. In 1969, when there was a mass dismissal of public sector workers, called Apollo 571 or so, the Salah and Agyemang case and all, the Supreme Court ruled in favor of the dismissed workers, essentially, and the Wizard government was compelled to comply, but the then Prime Minister made a famous remarks that no government can compel employment of workers. A year thereafter, 1972, there was a coup d'etat. In 1979, 1980, there was an attempt to remove the Chief Justice. The Chief Justice was subjected to parliamentary vetting, even though the Constitution, the letter, the spirit of the Constitution, the spirit in particular, because the Constitution was a little bit ambiguous in terms of the specific prescriptions as to whether a Chief Justice who held on from the military, the ex-military regime, should continue as Chief Justice. But the Supreme Court interpreted it to mean that clearly, yes, such a person was still a Chief Justice and should not be subjected to parliamentary vetting. The Chief Justice has been subjected to parliamentary vetting. She or he also in compliance with it, even though he did so under protest, subjected himself to vetting, and then was failed. And clearly, the reason was supposed to leave office. The Supreme Court intervened and said no. But that attempt to interfere in the judiciary is significant because a year later, there was another coup d'etat.
From the narration?
Yes, and then after 81, the gravest assault on the independence of the judiciary in Ghana was witnessed. 3 high court judges were picked up in the middle of the night and brutally assassinated. They were murdered in cold blood. It has ruined the scar and the conscience of the nation. And I think that these developments are very worrying, and therefore, when there is any attempt which clearly is unjustified to remove the Chief Justice, it ought to be brought in check. And we find a government which has come into office on account of the rhetoric showing an issue to deal with the judiciary, that the judiciary is biased and they need to clean it up, they need to reset it, and they need a new chief justice, and the new chief justice will help the nation better and all that. And so they come to office with such rhetoric, and then they embark on systematic patterns of conduct to give effect to that which is abhorred by the Constitution. I'm saying that the rhetoric that's the engaging, the kind of comments that were made by President Mahama were clearly the kind of sentiments that the Constitution of the country abhorred. The Constitution clearly, explicitly, in Article 127, clause 1 and 2, prohibits interference with the independence of the judiciary by Parliament, by the President, or by any person or authority at all. And so if a person comes to office as President and comes to the narrative that he's going to change the judiciary, he's going to deal with we need a new chief justice and all, and such rhetoric is repeated by key members of his government. We've seen Asedi Ketia make such comments, Mr. Fadbandi clearly say the chief justice has to go and all that. Then you see that, no doubt, we ought to be concerned about what is going on. So, and they know that they cannot achieve that except when they put or cook up a set of theory to suggest that the chief justice is unfit to occupy office and all that. I mean, so what do? They end up with all these spurious allegations. And if there's anything that the chief justice has stood for, it is her integrity. All those who have seen her work both in her previous private law practice since 1986, 39 years. I'm sure that's 39 is even more than your age. Yes, that's the length of career that she's had as a lawyer, 39 years. Then as a judge in the Superior Court since about 2002 or 2003 or so. So all those who are following her would know that if there's anything that she's noted for, it's her integrity. And therefore it becomes very puzzling, and that they would want to bring her down on account of the one thing that she stood for, her integrity, by suggesting that she spends some money unlawfully on her holidays. The holidays are part of her official package, is it not?
The argument is that the president really has no option in this. A petition has been sent to him. He's consulted the Council of State. The Council of State says yes, let the Chief Justice answer. He's further consulted, and they say let us step aside while the committee goes ahead to investigate, the 5-member committee, including 2 of her peers. The question people ask is that what really is President Mahama doing wrong?
No, I mean, absolutely. 2 major points of error on the part of President Mahama. Perhaps not error, but wrong. I don't know whether it's deliberate or not. First and foremost, he received the petition. He received 2 petitions in February, kept it to himself, engaged in consultation with the Council of State until the end of March, when he informed the general public, without even informing the Chief Justice. So the Chief Justice goes to work after having worked for God knows how long, and then one day wakes up to the news press that President Mahama has engaged in or started engaging in consultation with the Council of State on account of 2 petitions which were received 6 weeks before. That has been concerned, and clearly it is unconstitutional. The second point of grave constitutional violation is the determination of the prima facie case. It is not just that President Mahama has not done anything wrong in India, it's only a conveyor belt. That is no business of being a conveyor belt.
Could he have prima facie has been established?
It is not for the Council of State to make the prima facie intervention. It's actually for the President. The Constitution enjoins the President in consultation with the Council of State undertake the exercise. It's the President, and he does so in consultation with the Council of State. And I'm saying that in doing so, we ought to make a judicial. It means that you look at it critically against the evidence before you, and determine whether indeed there's a case of misconduct. And the misconduct and all other. There's no exercise her right to the holiday package that is guaranteed her under Article 71 of the Constitution. there's basis for misconduct. I mean, and the most grave violation is when he refuses or he fails to give a reason ruling. So the prima facie determination that I have seen, and which I've attached in my processes before the Supreme Court, was just simple. The Council of State has been consulted on the petition before the Council of State is of the view that there's a case for it to answer in front of the 3 petitions.
That's only that?
That is the only, yes, it's all before the court.
You think they should have gone ahead to analyze the petitions and the response from the Chief Justice and giving reasons why you think that despite the responses, she still has to answer?
That's the requirement of the law. That's the requirement of the law. And the law requires it to have a prima facie determination. That process is a quasi-judicial one. It requires a careful evaluation, why the requirement petition against the responses. Which of the specific allegations contained in which of them and all? What are the specific reasons? What are the ones that there was no case to answer? So clearly there was no proper determination.
So this is one of the reasons the Chief Justice herself has gone to the Supreme Court.
That's one, together with the contention that I think we must, we just stop being hypocritical in the country. And we must have a regard for due process. This is the head of the Ghanaian Judiciary, being purportedly subjected to proceedings for hair removal. She has not been given a copy, or she had not at that time been given a copy of the petition until she requested for the petition. She has not been given reasons for the prima facie determination by the president. The 10 members of the government are out on radio, TV, and internet talking about the petition and how it was bad that the Chief Justice used money for the asthma statement and all that. So the essence of the petition is actually out there. You have seen the contents of the petition out there. You have seen what purports to be her responses. I don't know what that were her responses because indeed she has not shared them with anybody at all. And so everything about no, because my duty now is to challenge the constitutionality of the process. It's not about.
So you're not representing her before the committee.
I think. Let me just make the point before we digress. So the point I make is that everything about this petition has been put on the public domain already, and the Chief Justice has been damnified and condemned and all by leading members of the government and all. And when it comes to her side of the case, the opportunity for her to state her side of the case, then the state requires that it should be in camera, it should be in secrecy. It cannot be in secrecy. There ought to be light on the proceedings because she has already been damaged the public domain and all that, and all, everything is a problem. And I think that the most effective weapon in all of this is to shed light on the proceedings. What's the warrant for secret proceedings when indeed everything has been discussed every week? I'm sure your station definitely has discussed the petition. You've discussed all your Saturday programs and all that, and the content and the analysis here and there. Then when it comes to her, for her to state aside the case, she should be in the dark.
Proponent of this view says the obstacle is in Article 146.
No, it is not. It is not. That is why we brought the case for interpretation of the Constitution. And that's why I also speak on the spirit of the Constitution. In many cases, the issue of the country to foreign attention or many other matters, we find the Supreme Court, even at Gertrude that you referenced earlier, and indeed I was not in at Gertrude as counsel. There was no Hanson Agyemang. The Supreme Court has had to read certain words into the Constitution when necessary. It's the basic rule of interpretation that give effect to the Constitution if it is clear and if it serves the purpose of the provision. But where the plain words of the provision will lead to absurdity or will lead to irrationality, the Supreme Court will look at the purpose of the provision, and that's what we call the purposive interpretation. Read means to give effect to it. Now I'm saying, if you look at the Constitution as a whole, starting from the provisions on fair trial in Article 19. We talk about Article 19 clauses 13 and 14, which talks about authenticating authority. That is not the court. It is in reference to such authenticating authorities. Then you go to Commission of Inquiry in Article 278 onwards. And the 281 especially enjoys that provisions, proceedings of the Commission of Inquiry ought to be public. And Article 295 constitutes Commission of Inquiry to include a committee of inquiry. So in my view, except where the concerns of public safety, public morality, public order will require, proceedings of any authenticating authority ought to be open to the public, especially when it is set up or is done under the Constitution. And in this case, these provisions are, or these proceedings are being conducted pursuant to Article 140 of the Constitution. And I'm saying that there's nothing which threatens public harm, public order, or public safety in these proceedings, such as to warrant that it should be in the dark or it should be in camera. On the contrary, we think that the conduct of the government so far, together with what has witnessed in the whole of the proceedings, will rather require that it ought to be in public, because it's only on account of that proper justice and fairness can be served.
Now, apart, in addition to the relief, is a relief for that warrant that was signed by the president that accompanied the prima facie determination to be revoked. On what grounds are you making this? Primarily, if really proceedings are conducted on account of false basis, if the basis for the formation of the committee is an unconstitutional act by the president, which is that the determination of what the purpose of the prima facie case, and that's not exist at all. Then clearly, it is null and void, then the warrant of suspension ought to be suspended, because that warrant of suspension was issued in consequence of what the president represented to the nation as the determination of the prima facie case. And I'm saying that prima facie determination was none at all, was null and void, because it was not done in accordance with the details of the Constitution. And on account of that, it ought to be set aside. Let's take the objection to members of the committee. For Justice Scott Palmer, the point you make in that suit is that he has given favorable judgments to one of the petitioners. How does that rise to the level of he not being able to be part and chair the committee?
I think, and we make that case not out of any, without prejudice to the relations I have with Justice Palmer. I've known him for quite some time. I like him a lot, not for any reason, but the mere fact that, yes, he was actually even the chairman of the Council for Law Reporting when I was at NJORA. So I've had very good relations with him about that. So I do that not because of any feelings at all or towards him, but just because of the principle. The Chief Justice is being removed from office on account of a matter that she conducted in the Supreme Court, which is the Akogo matter involving the policeman. The policeman complained because of that matter, that the Chief Justice made some comments and all that. And it did just or everything that was done by the court. So on what account you single one member of the court out for removal because of what was done in the matter, and then you make another member of the same panel president or chairman over a committee set up to inquire into the conduct of the Chief Justice. I think that clearly it cannot be right. Even in the course of Ghana, when the matter is said by a judge at the High Court, and the judge has been promoted subsequently to the Court of Appeal, and the matter comes up for hearing at the Court of Appeal, the judge will not sit on the matter. If the case accidentally placed before a panel, including that same judge, and the same judge will just wash his hands off. So we think that the formation of that committee was wrong. Apart from that Akogo matter, Justice Palmer also gave 4 judgments in favor of one of the petitioners, again, the same Danofori, who on which panel the Chief Justice also said. So it cannot be right. I think it's.
But do you think that there might be a problem with the judgments is delivered for the Nofori, or is just a matter of saying because he's presided over cases that involve the Nofori, that he cannot be part of a committee investigating a petition brought by the Nofori?
I mean, it goes without saying that if a judgment was given by Justice Gertrude, in this case was not just one judgment, but about 3 or 4 judgments in favor of the same person, and matters relating to the matter are the subject matter of the petition. He cannot be on the panel. It goes without saying. I don't think it's something for us to find difficult to accept. Again, if he was part of a panel of another case, the Akobo matter, and Akobo says on account of how the court treated him, the chief judge says that everything was done by the court. There was no single ruling by her or separate ruling by her as a judge. It was ruling by the court and all that. How can a member of that panel be selected to sit on it? It's a no-brainer, really.
Just as a legal issue, he only elected by the suspended chief justice to preside over the injunction application that you had at the court, and based on that, you say he cannot be a member?
Yes, because for me, it has far-reaching implications for the independence of the judiciary, because it means that whenever the president wants to frustrate the hearing of a matter, all the president will have to do is just to appoint a judge to serve on a committee set up in the ministry. So most of the time, the attorney general has cases in court because there are many cases involving ministries, departments, and all that. If even a minister feels that the judge is not going to be inclined towards him or her, has to do is to set up a committee and appoint the judge onto it. And I think that in this case was improper. That's the same one, a panel to sit on the matter. And then the next time he was lifted from the panel and put on this other committee which has been set up to investigate or look at the chief justice.
But what do you say to those who say that the judge is happy to fail Justice Sekudwo? Could prematurely halt the entire proceedings, but she's a problem hearing the
No, I mean, right to challenge any aspect of proceedings that are illegal or offensive to due process or procedure or even to the Constitution. And in this case, I'm saying that they have very grave violations of the Chief Justice's constitutional rights. It's also not a matter, the violations are not of such a nature as to affect only her. It has a direct effect on the integrity of the judiciary. And we think that we are reviewed in order to avoid such to be a proper judicial intervention.
For the other 3 members, you objected to their qualification to be on that committee as well?
Oh yes, because we have cleared the oath, the oath of office before being properly vested with power to adjudicate. It's something for the court to tell.
So you can't do it whether they are lawyers, they are not lawyers, they are not members of parliament, not members of parliament. They meet that bill, but they did not take the oath of office to be able to be part of it.
So our query is to the failure to take the oath of office. So that letter would interest you. His matter came up in the Supreme Court. The Chief Justice voted in favor of that. So really, I mean, as I always say, all these attempts by the NDC to move the Chief Justice are unjustified. Control the judiciary. I mean,
take control of that.
That's essential rhetoric that was by President Mahama. Now the kind of thing here is when the council power, they throw themselves up, they will be appointing them to the bench and because by MPP and all that. It's abhorred and prohibited by the Constitution. It's a very serious matter. And he's seeking to give effect to that thing which is prohibited by the Constitution. And I'm saying that you have done so by cooking up all these allegations against the Chief Justice.
So you believe this is overriding consideration?
100%. So that's it. And throughout the proceedings, the NDC people have made statements like Mr. Fagbande and other people, the have said that, this year.
Some have questioned why you are so vested in this case, and they think that as a former Attorney General, as a member of the New Patriotic Party, at best you should distance yourself from this case, and the Chief Justice ought not to have even engaged you.
Chief Justice has the right to answer. She does so taking into account the specific matter that she wants to take to the Supreme Court, assessment of expertise of the lawyers and whatever. It's a basic requirement. I think the record too ought to reflect the fact that if there's any attorney general who has spoken against interferences with the independence of the judiciary, it is me. Right from day one, when I was appointed as Attorney General in 2021, my wedding bar conference, I gave a speech for the Tanga, that's deploring the unjustified attacks on the judiciary, and continue my bar conference at Google. It took a short for suggesting that the judiciary ought to be cleaned up and that it was going to change the judiciary and NDC loyalty and all that. And that's so. If you critically take a look at it, the source of all the problems people have is the judiciary. The source of the problems that NDC lawyers can have with me is actually that speech by me at the bar conference when I went all out in certain terms, kind of damn by President Baba. So what I'm doing now very much is two for but now before I came to public service, I used to stand up for the judiciary, and you would never find me on any occasion attacking the judge. Never at all. Last 2 weeks in Supreme Court, actually made a point that that was I was objecting to the judge. That's why the acting Chief Justice, because of the special circumstances of the matter. I have one judge and one lawyer who on every occasion has always recognized and sought to uphold the dignity of thought at all times. And so whenever there's any attempt to encroach, is recorded off, I would definitely speak against. And I'm saying that when they do so, it has a far on the democracy that we practice. There are democratic credentials go down if the Chief Justice is removed.
Well, when you suspend the attempt to remove the justice, it's politically motivated. There are those who are saying that you're stoking more to it by being a politically exposed person. I mean, the Chief Justice could have found a lot of analysts out there who also are interested in the independence of the judiciary. Why this Dame, who is a member of the NPP?
But I think the point also to be noted that all the counsel for the petitioners, all politicians and politically exposed persons. Nobody can be more of a politician than Sadiq Kata. President Mohammed's lawyer in the 2020 presidential election petition, who subsequently became lawyer for Daniel Fori in the court, and the same Daniel Fori turns out to be the petitioner. Chief Justice said that same person who was President Mohammed's lawyer now is the lawyer trying to Chief Justice before the committee of inquiry. It's very, very serious. The president's lawyer, Kata, is the one who is leading the assault against the Chief Justice. And then Sorry, lawyer of Parliament of unpack, also leading the charge against the Chief Justice. So you see two arms of government, the executive and the legislature, their respective counsel are the ones going against the Chief Justice. And then you find the President office and did all kinds of activities and people government also passed the team. So if there's any group of people who have actually politics, and I do not think that my entry into it is the story at all. My record of defending the judiciary and standing up for the independence and justify interferences with that independence, which is assured by the Constitution, is a record of conducting constitutional cases and all that. It also there for all to see. But I think all these statements more or less are a distraction. Or to look at the merits of the public, or to examine the merits of justice. Let the Supreme Court.
Can you win this war? What you replied is that the Tijuana, those who are saying that she should actually even resign and save us all of this.
Save Government, resign for the democracy. I think that the short way of eroding democratic credentials of the nation is for the public to subscribe to attacks against the Chief Justice, who is the head of the judiciary. The shortest way of Ghana's democratic credentials are destroyed is for the public to support the attack by the president, the government, to destroy the judiciary. Who would want to say it cannot be at all. Judiciary one person should be cordoned off and protected against any attacks on its independence, and that is what we stand for.
Now, the case that you filed suspended Chief Justice, have you heard back from the when you're supposed to go to court when hearing this?
Well, the application for the interlocutory justice has been fixed for Wednesday, 28th of May.
Wednesday, 28th of May.
Yes.
The issue also has to do with the perception that the judiciary has been unfair to the NDC, and perhaps reasons for some of these actions. I mean, the Minister of Government Communications has on a number of situations indicated that on one occasion, actually, the minister in charge of government communication, he gave an indication that the judiciary has been he makes mention of cases like versus the Attorney General and all those cases that, and even in the time when we were Attorney General, there been a chorus of Supreme Court being a unanimous. People think that this perception really also adds up reasons why people may want to take justice out.
So people seek to mock the courts of Ghana, and then we must all subscribe to it, or after mocking the courts of Ghana, we must do it on. I mean, we want to give effect to the kind of narrative that we want to turn out. I think that comments clearly are unjustified, misleading, and with all respect, unanimous decisions are given by the committee. Just 2 days before, 2 days ago, Tuesday, was a unanimous ruling in my favor. A panel that is the Bafuboli, Tanko, Kulendi, Dakwasari, and I think Kofi. There have been various decisions that have also been unanimous that fought against government, but that was in the House of Federal. The Dominic matter, I think, was unanimous against the government. The challenge of the COVID-19 was also unanimous. It was against the government. So the point was that to be controlled. The further decision is unanimous that you do not like that, sorry, that they must stop giving answers. Indeed, recently, the same day that the Supreme Court did a 3-2 ruling, anyone that had given a proposal unanimous against me, you've never heard criticized the judiciary for giving a ruling. When the decision on the interlocutory injunction was dismissed, I never criticized it. I was agree with it because there's freedom of expression, freedom of thought in the country, and all that. I was agree with it, but that's where it should end. So I think we
Now, May 28th, you're going back to court. Have you spoken with the suspended Chief Justice? How that's taking the toll on him?
You are the strongest man I've ever seen. So I was reflecting on the word of God, very strongly by the word of God. And I remembered that yes, David wasn't able to defeat Goliath. Just used a very supposedly low cost of death to defeat Goliath. And so the confidence and trust in the word of God knows that that is why she wants light to be shed on the news. That is why she wants a public hearing, public to hear. So far, never made any comment at all. Whilst people and the opposition in public. Two, she also said that she remembered, in the time of her reflection on the word of God, she had to remember that a really powerful man. Clinton went through an impeachment trial, and that was the person who was supposedly, and the president of the United States of America, the most powerful person, he did the free world and all that. At the day, she also had a day that reflect on the word of God, and she knows that truth will surely come, in darkness, which is what she resists.
Finally, what would you say to persons who may believe in your views but seem to be mute at this particular moment?
I think it's important that women, very important that we all stand up for what is right and what is virtuous. There's never been a time there has been such a grave assault on the independence of the judiciary. In the fourth republic, as what we see now. So you see what they do in 7 charge at a court. The street clearly take control of this. I don't know what control means, because the same judges that they claimed were biased when Akufo-Addo was in government, and the judges also really in their favor, but the judges are biased. Contradictions in the conduct. They do what the young people will say gaslight. Exactly what they are doing. They say, "Oh, you rather do a way of that you actually believe that you are doing the same thing." Even though you are not doing the same thing. After the 7 judges have been promoted, allegations that judges have been promoted, and the chief judge was sitting on the court and all that. That has been the law of this country. After the 7 judges that have been promoted, many of them are junior on the Court of Appeal. Some of them were even appointed to be by President Akufo-Addo a year or 2 ago. They have been sent to the Supreme Court now. Some were appointed 3 years ago. Many of them actually sworn in my tenure as attorney, but they've been sent to the Supreme Court now. So what is the justification for saying that of making all these allegations against Akufo-Addo? So you see, there's a lot of contradictions, hypocrisy, and bad faith in the actions of this government. I think that all good men ought to stand up.
Thank you very much. So that is Godfred Dame, speaking to you from his chambers here at Dame and Partners. We'll be in court on May 28th to follow up on what will become of that application, and also follow this for you on TV and City FM. My name is Hanson Agyemang.
Good.